Today's event is the Bruce and Bruce Show. Bruce W. Sanford is a partner in Baker Hostetler, specializing in press law. He's been involved, according to the firm website, in more than 1,000 cases, which strikes me as an astonishing number, litigating issues of libel, intellectual property, and First Amendment. He's general counsel to the Society of Professional Journalists and among the most prominent press lawyers in the nation. He's also of particular relevance to us here, the chairman of the board of trustees of the Thomas Jefferson Center for the Protection of Free Expression, and in that sense, our host and benefactor for this event. With him is Bruce D. Brown, also a partner at Baker Hostetler, and also a top media lawyer, who also works with the Society of Professional Journalists and litigates in the areas of libel, invasion of privacy, copyright, and pre-publication review of manuscripts to scan for the avoidance of such problems. Bruce is also a familiar and valued member of the University of Virginia community because he teaches here in the First Amendment Clinic, which, like all clinics, unfortunately is limited to a relatively few students, but provides those few students with an extraordinary opportunity to participate in the drafting of amicus briefs on First Amendment issues under the auspices of Bruce Brown and Josh Wheeler at the Thomas Jefferson Center. So, Bruce Sanford, I turn the evening over to you.
Thank you, John. It is not true that everybody at Baker and Hostetler is named Bruce. I am not here as a speaker today, lucky for you. I am here as the chairman of the board of the Thomas Jefferson Center for the Protection of Free Expression, which is the institute here that vies for the organization with the longest name. A friend of mine in Washington, when I spoke the whole name of the center one time, said that sounds like a communist front. I have a Halloween treat for you today, and that is to let my colleague Bruce Brown talk about some of our reactions to what we heard this morning and some of our perspectives which may surprise you as practicing lawyers in an area of First Amendment law increasingly permeated by tough questions about the tension between disclosure and the protection for anonymous speech. Mark Twain one time said about, Mark Twain I think was a pen name, wasn't it? Mark Twain one time said about Henry James, who he did not like, that when you put down one of his books, it's hard to pick it up again. I don't feel that way about the symposium this morning. I certainly won't feel that way about the journal's publication. And I really want to thank John and Josh Wheeler, the director of the Thomas Jefferson Center, and all the thoughtful and articulate speakers this morning who worked so hard on what may surprise you is really, and we intend it to be, the first of many annual symposiums on First Amendment law at any major law school in the country. And I'm so proud to be associated with it. And thank you, John, Josh, and to all the speakers. 21 years ago, the Thomas Jefferson Center was founded with money from the New York Times Foundation and the Warhol family that then owned the paper here in Charlottesville. And we lucky to have as our director a man we honor at a dinner tonight, Bob O'Neill, who'd been president of UVA and then returned to teaching law at the law school. We've had a glorious 20-year run, and as we enter our third decade, we are looking forward to having a closer collaboration with the law school than we have in the past. To use John's wonderful phrase, we want a firmer handshake with the law school, and this symposium is just one example of that. Another example is that John has joined our board. which is terrific. We have a wonderful board and have had many terrific people over the years. We've got Sissy Spacek. We've got former president of the ACLU, Norman Dorson, a distinguished law professor at NYU. We've had Elaine Jones, you've heard about. This morning we have Britt Hume, we have Sheila Tate, who was the press secretary to Nancy Reagan and the campaign press secretary to the first President Bush, and we have wonderful president of the Scripps Howard Foundation, Mike Phillips, who generously supported this symposium. It's a great board, and we're glad to have John on it. Kelly Carlin is yes, George Carlin's daughter, Kelly. Where's Kelly? Where's Kelly? There she is. She's just joined our board, too, and she's just flown in from the West Coast, so we're glad to have her. Should be spicier at our board meetings, don't you think? And thirdly, in terms of the closer collaboration between the law school and the center, you have this year an expanded First Amendment clinic, and you have for the first time not just Josh Wheeler working on that with law students here, but you have the help of a real live practicing media lawyer, Bruce Brown, who's been thrilled to be participating in that, and we're thrilled to have him do that. Having said that, it is really nice to go to work every day and have colleagues like Bruce who make it fun to practice media law and engaging and terrific. And you're going to see some of that as he talks. The other thing that if you are a media lawyer or a First Amendment lawyer, you have to let everybody in the practice group speak their mind all the time. And so in introducing him, I will only say that as I sat here this morning listening to all the sort of politically correct talk about the values of disclosure, which of course is very true. There are many values of disclosure. And for years, I, as a press lawyer, bought into the conventional bias of our clients in the media that disclosure is virtually an absolute pure value. We would quote Brandeis all the time about sunshine is the best disinfectant and constantly argue for transparency and access to information of all kind. Actually, sunshine is not the best disinfectant. I think Clorox wipes are much better. But be that as it may, I'm here today to tell you, and I think Bruce may echo some of this, that anonymous speech has value too. And that what worries me today, a little bit less with all the anonymous speech of the internet, which I think will help us out, but what worries me about campaign finance today is what I call the Ashton Crutcher effect. And I pick on him because I know all kinds of celebrities like him, and not just celebrities, but well-resourced people, let's call them rich people, who will not give political contributions because at particularly generous levels that they're capable of, because they don't want the disclosure, the criticism. They don't want people to know their political views. They say, you know, I got a secret ballot. I ought to be able to give secretly as well. And I think we ought to think about that, about the value of, about the self-censorship, about the deterrent to the speaker and the speaker's autonomy with rules. And thresholds, giving thresholds could cure some of that. May cure it for the doctor at the Mayo Clinic or the executive at Procter & Gamble who doesn't want to give political contributions because he doesn't want to be, you know, thought of as this or that or this political persuasion or that. He doesn't want it, or she doesn't want it to get in the way of a career. And so I worry about that. And I think it may sound strange for you to think of a media lawyer talking about the value of anonymous speech, but increasingly we see in our practice episodes and times when we're called upon to defend, and this is particularly true of our blogging and internet clients, the value of anonymous speech. Having said that, I told you I wasn't going to speak. I'm going to turn it over to Bruce Brown.
There it is. Thank you, Bruce. Thank you, John and Josh, Mike. I feel like I've been on the mountaintop this morning, hearing the panelists talk about the way First Amendment theory should play out, and then I'm the practitioner who slogs up here with the mud all over my shoes, literally today with mud all over my shoes, to talk to you about some of the cases that Bruce and I have worked on together through the years. In thinking about this, I first thought that we had really never had a pure anonymous speech case. But when I went through some of the litigations we've had together, I realized in just how many different cases we've litigated, there have been issues that have come up regarding confidentiality and anonymity, anonymous sources. I'm going to speak for a few minutes trying to highlight some of those. The first area, one that's been on people's minds certainly over the last couple of years, is the reliance on anonymous sources. And you're a news organization, and you've been subpoenaed before a grand jury, and you want to protect an anonymous source. I think we ought to get rid of the word leaks. Toilets leaks. Garden hoses leak. But to describe the texture of the complicated relationship between reporters and sources as involving leaks is simply not very helpful in an appreciation of how valuable those relationships are to all Americans. That is something that Bruce said in a speech to the Newhouse School of Journalism not long after we had written an amicus brief supporting Judy Miller in the D.C. Circuit when she was called upon to disclose anonymous sources who had told her that Valerie Plame was a covert CIA agent. The question of protection for anonymous sources for journalists has actually been with us much longer than people may realize. Maryland was the first state to pass a SHIELD law, and it was enacted all the way back in 1896 when the legislature acted after a newspaper reporter was sent to jail for refusing to tell a grand jury how he had learned that certain members of the city government were being paid off by those who ran illegal gambling establishments. Imagine that going on in the city of Baltimore. And that was the origin of the first state SHIELD law. And states followed slowly, but then a body of precedent finally gets created in the federal courts in the 1980s and 1970s based upon one of the most scrutinized double negatives in American media law jurisprudence, Justice Powell's comment in a brief concurrence in Brandsburg versus Hayes, where the court as a whole had rejected the idea of a First Amendment-based privilege for reporters to withhold the identity of their sources before grand juries, but Justice Powell said, quote, "The court does not hold that newsmen subpoenaed to testify before a grand jury are without constitutional rights with respect to the gathering of news or in safeguarding their sources." And after that wonderful double negative, virtually all of the federal appellate courts in the country ended up adapting something of a qualified privilege to protect newspaper people when they were asked to disclose the identity of their confidential news sources. And it's not a coincidence that this law was developing at a time when things were going pretty well for the news media and the courts in general. They were winning access cases. They were winning libel cases. And the development of a qualified privilege under the umbrella of Justice Powell's concurrence was a part of all that. But today, the pendulum has swung the other way. The reporter's privilege is now a disfavored body of law, and our experience in our practice has been that when we counsel reporters about the risks of withholding a source's identity from a prosecutor, even in libel litigation, where there's not a it's not public litigation, but litigation between two private litigants, that the judges are just sort of turning decidedly against reporters who try to invoke these protections under the law. And so what happened? Well, Judge Posner wrote a very influential decision about 10 years ago where he rejected a qualified privilege for the Seventh Circuit and called into question why other circuits had followed the rather, I would say, obscure endorsement that came from Justice Powell in Brandsburg, that it was not a full-throated endorsement of a reporter's privilege, but rather one that was anticipating that courts would handle these issues on a case-by-case basis, and perhaps, if they found harassment of a reporter, intervene, but otherwise it was not a categorical endorsement of a privilege. The September 11 attacks came along, and that certainly put us in a position where prosecutors felt that they had compelling government interest in when reporters were perceived as withholding sources that could be helpful in national security investigations. And then on the journalism side, we had the Jayson Blair controversy at the New York Times, Janet Cook at the Washington Post, where newsrooms lost some of their credibility when it looked like there weren't proper safeguards in place to ensure that reporters weren't fabricating the identity of sources, or in some cases even the subjects of their stories. And certainly also on the newsroom side, there has been just a tremendous growth in the use of anonymous sources. And I find sometimes I choke when I'm reading the sports page, and I find that someone who works in baseball operations for the Washington Nationals requested anonymity to talk about the lineup and what it might look like next year because he was not authorized to speak on this matter. And we get those long explanations in our newspapers now because I think, to go back to something I think Helen said this morning, that there is a perception in newsrooms that providing more information to the public about why a particular source is requesting anonymity does enhance the value of allowing the reader to make more informed decision-making about the content of the blind quote. And so you'll find today that in most newsrooms, before anonymity is granted to a source, that there is a complicated description that will be developed as to how the source will be identified in the story, so that the reader understands any inherent bias that the source may have. But to get back to vocabulary and to Bruce's use of the word leak when he spoke up at the Newhouse School, we have felt that the vocabulary needs to change in order to bring the law back to a direction where judges are again comfortable protecting the relationship between reporters and sources. The word leak does not appear anywhere in the Brandsburg decision. The Pentagon Papers came down just a year before. Justice Marshall is the only one who uses that term in the Pentagon Papers. And Brandsburg came down in June of 1972, at a time when really the great Washington leak scandals hadn't developed yet. And even though the DNC headquarters had just been broken into, in June of 1972, Woodward and Bernstein were still reporters on the Metro staff of the Washington Post, and the Watergate was just a not very attractive apartment building. But today we live in a climate where leaks are so prevalent, and the courts, I believe, are perceiving them as an exchange of information from the politically powerful to the media elite. And that word leak that has such a negative connotation today, I think with having Kelly Carlin in the audience, I mean, the word leak is now the single dirty word in reporter source privilege law today. And when I looked at the Judy Miller decision, the one that I mentioned earlier where Bruce and I had worked on an amicus brief, and Judy, of course, lost that case and went to jail, the word leak appears almost 40 times in the opinion. And so if you see that word as having a kind of negative connotation of how the courts are looking skeptically at what they see as a game of spin that the political establishment, either on the governing side or on the news media side, is playing, I think we'll continue to see not a lot of sympathy in this area, and certainly sympathy from the courts, and certainly not even from Congress. We tried very hard through the Society of Professional Journalists and other lobbying organizations to see if we could get a federal shield law passed after the experience in the D.C. Circuit with Judy Miller. And even after several years of watering down the protections of the shield law, so that by the end of the day it was not even half of what the news media was hoping that it would be, we still couldn't get it passed. There's just not an appetite, I think, in the courts today, or an appetite in Congress to, go back to a more robust protection for reporter-source relationships. Another area that we see anonymity come up, but it's been a little more encouraging for us, is that in this new world of the explosion of media platforms, news organizations are interacting with their readers and their sources in so many different ways. Readers now can go directly onto newspaper websites and post comments. Many of them do so anonymously. And we as news organizations are also learning a lot more about our readers from the online data that's available to us about the people who visit our websites. And there is a very nice body of law developing protecting anonymous speakers who go on to newspaper websites and they make comments about the day's news or things that are happening in their community, and then they are sued for libel. And if they, perhaps someone out there thinks that they've crossed a line. And when they're sued for libel, the newspaper is often sued along with them. But thanks to the Communications Decency Act and Section 230 of that legislation, the newspaper companies have immunity from those libel suits because they are not creating the content when the individual readers go on and post comments about the day's news. But they are brought into those lawsuits because the plaintiffs are after the John Doe defendants. And so they go to the newspaper website and they demand the identity of the reader who has posted the allegedly defamatory content. And this is an area where there's been some good law that's developed. We worked on a case out in the Eastern Shore of Maryland for a company called Independent Newspapers, and they were brought into a libel suit where the plaintiff, Mr. Brody, was looking for the identity of a certain Rocky Raccoon. Mr. Raccoon, or Mr. Rocky Raccoon, maybe I should say, not very original as a handle, I should say. As a Beatles fan, I can imagine that there are many other, he should have been Rocky Raccoon 101, but he was just Rocky Raccoon. He had gone on to a website and disparaged a local Dunkin' Donuts. This is the stuff, folks, that great media law is made out of. He said, I wouldn't go to that Dunkin' Donuts of Brody's. Have you taken a close look at it lately? One of the most dirty-looking food services places I have ever seen. So Mr. Brody brings a lawsuit. The newspaper gets dismissed under Section 230. But what about Mr. Raccoon? He wants to know who Mr. Raccoon is. And the newspapers, by and large, have done a really good job defending the identity of these kinds of anonymous posters. And I think it is just something in the DNA of newspaper companies that even though these people are not sources the way we think of the body of law under Brandsburg as about protecting our sources of information, there are readers. There's a special relationship between publishers and readers, and the newspaper companies have defended these cases. And Brody, we got a very good decision that set a higher bar for the disclosure of an anonymous poster like this. And I could give you the 6-part test that the court developed, but I think what Bruce would say the basic test is, in a case like this, is there a dog of a libel suit underneath this thing, or is there something substantial? And what the court did in Brody is it said, no, we're not going to go with a lesser standard where the plaintiff would just have to show a good faith belief that if he gets the identity of the source, the poster, I should say, that he'll be able to prosecute and win a libel claim. We're going to look at the strength of the libel claim right now, and we're going to see whether there's a prima facie case of libel or defamation, and if there's not, we're not going to disclose the identity of the source. And that was a great win, and there are a number of cases now out there along the same line where I believe in addition to Maryland, New Jersey, and maybe California, they've now adopted a test like this, and it's very protective of the right of anonymous posters on the internet. Another case we had, also out in Maryland, involved a newsletter publishing client that had come out with a very exuberant stock tip for alerting readers to a company that the writer thought was poised to double on some news that was going to come out of a U.S.-Russian summit. And the writer ended up being right on. This was a stock that, in fact, eventually tripled. But the stock did not end up going up on the day that the newsletter writer thought that it would. And because he was writing about securities, there was some interest from the Maryland Securities Commissioner. And the Maryland Securities Commissioner, seeing that there had been some activity in this equity, and it was a company that was based in Bethesda that the writer had covered for his readers, sent a subpoena to the newsletter publisher asking for the identity of every single reader who had received this tip, because they wanted to explore whether the people who got the information bought the stock based on the tip. Did they think that the recommendation provided accurate information? Did they believe that the fact that the reporter sourced the information to someone in the company, was that relevant to their decision to buy the stock? They were interested just to see if there was anything going on other than the purchase and sale of information. And we briefed this case as, in our kind of megalomaniac way, as all about being the interest of the publisher, that the publisher had the right to protect his relationships with his readers, because if publishers couldn't be certain that their readership lists would be protected, that no reader would subscribe to a newsletter publication like this, knowing that their name and address and some other information, email address about them, was in a newspaper or newsletter publisher's files. And this was a little bit of an uphill battle because the subscriber lists are business records. You can invoke the reporter's privilege law in a case like this, as we did, but we weren't trying to protect the relationship with sources. We were trying to protect the relationship with our readers. So I learned a couple things about the practice of law in this case. One was, when you represent the media, don't make it about you, because when we got a good decision out of the Maryland Court of Appeals protecting these subscriber lists, it was all about the readers for the court. And I know one of the panelists earlier this morning was speaking about listener autonomy versus speaker autonomy. Okay, that's not how we wrote it in our brief to the Maryland Court of Appeals, but clearly it was all about our autonomy as newsletter publishers to keep this list confidential. And for the Maryland Court, we were almost it was almost an incidental thing that the issue came up because it was the publisher contesting the subpoena. What was incredibly important to the Maryland Court was that there was a right to read anonymously. And even though we were dealing with business records, they set a heightened bar for the enforcement of the subpoena, and the subpoena was quashed. And it was a wonderful decision. It was not the decision we thought we would get, but in terms of protecting the right to read anonymously, protecting the interests of readers in an era in which it's easy for government regulatory agencies to go searching for information about them, it was a great decision. The second thing I learned was the following, that when we got to the Maryland Court of Appeals, one of the things the client said was, you should really say in oral argument that this is an important issue because there's some guy who wants to get Playboy magazine at home and he doesn't want anyone to know about it. And I said to my client, that is an embarrassing argument. I could never make that argument. It's below us. It's lowbrow. This is an important First Amendment issue. And 5 minutes into the oral argument, one of the judges sitting on the bench scratched his head and said, well, now what about the fellow who gets Playboy at home? I learned the importance of listening to your client. It turns out they actually know a lot more than you do about their business. So I think we'll continue to see some interesting developments in the area of reporter source and of reader anonymity. Just two I'll flag quickly. Fascinating op-ed in the New York Times this week about encryption and whether newspaper companies should be encrypting relationships with confidential sources, the email traffic that goes back and forth. And he made the point that WikiLeaks, and we're very known in the media these days for not being terribly sympathetic to the project of WikiLeaks, but that WikiLeaks has done a terrific job protecting the identities of the individuals who had provided information to it, and that Private Manning's identity, I didn't realize this, was only disclosed because of some acquaintance who was aware that he was a source for WikiLeaks. That otherwise their communications have not been breached. And this op-ed writer said, what about the newspapers? The newspapers make promises of confidentiality to sources, and then the reporters get on Gmail and email their confidential sources back and forth. And that in an era in which we do have a Supreme Court decision saying that, in the Cohen versus Coles Media case, saying that when a reporter makes a promise to a source of confidentiality and then discloses the source's identity, that can be subject to a tort action. Maybe we will see a case one day of a source believing that he or she has a cause of action against a newspaper because they were not encrypting communications, even though they had made a promise of confidentiality. Another interesting area in this subject, before I briefly go on to some libel cases, who does the source belong? Who does the privilege belong to? That is a fascinating question that has not been treated very frequently in the courts. Does it belong to the source, or does it belong to the reporter? And And I think that we will probably see some more cases where that issue is litigated, particularly where you have government sources who eventually are encouraged to release a reporter from a promise in exchange for some deal with the government, and then the reporter still doesn't want to testify, even though the source has released the reporter from the promise. That came up in the Judy Miller case. The D.C. Circuit felt the privilege did belong to the reporter, but I think we'll see some more cases in that area. Finally, I just wanted to talk for a few minutes about some libel cases we've had and the role of anonymous sources in libel cases. And I'm prompted today to do this partially because of the death earlier this month of Reverend Fred Shuttlesworth, who was a great leader in the civil rights era and passed away the same day that Steve Jobs did. And the obituaries of him, I think, in some ways got buried because of the avalanche of attention to Jobs. But I searched through the obituaries I could find, and nowhere did I find the little tidbit that interests a media lawyer, which is that the Reverend Shuttlesworth was one of the great anonymous sources in American libel law. He was in Birmingham in the early 60s, as you know, and Birmingham then was run really as a city of terror under Bull Connor, and they don't really make libel plaintiffs like Bull Connor anymore, thank God. But and the New York Times sent Harrison Salisbury down to Birmingham to do a story about racial tension in Birmingham. And the case that grew out of that, New York Times versus Connor, is, I guess, the little New York Times case. Everyone talks about the big New York Times case, New York Times versus Sullivan, which of course was mentioned several times this morning. But New York Times versus Connor is the little New York Times case, but in so many ways it's just a beautiful and important case. If New York Times versus Sullivan gave us the rules, New York Times versus Connor gave us the execution of the actual malice rule. And in that case, Salisbury quoted individuals in Birmingham as saying of Bull Connor that he had made the statement that, quote, down here, damn with the law, down here we make our own law. And it was unattributed in the story as to who the source was. Bull Connor denied making the statement. The statement would be defamatory, of course. He had witnesses who came to trial who not only said that he had never made the statement, but he would never have made a statement like that. And the jury tried the case under the New York Times rule on remand. The jury found actual malice, so the New York Times had a judgment against it. And it goes up on appeal, and the Fifth Circuit reverses. And by the time it got up to the appellate court, it had come out that Reverend Shuttlesworth was the source for Salisbury. But he did not testify at trial. And all Salisbury had were notes in which he said that he had heard this quote from Shuttlesworth that Bull Connor had made. And in a really kind of an amazing decision, the Fifth Circuit decides that a single-sourced allegation in that story, based on a comment of a source who didn't even come to testify at trial, was sufficient to overturn the jury verdict. And I'm struck by something Fred said earlier today, because in years since, I've tried to, when I've had cases similar to New York Times versus Connor, said to the courts, my case is just like Connor. You've got to overturn this jury verdict because my reporter is just like Harrison Salisbury. He had a single source, It was an anonymous source, but no red flags came up. You've got to overturn a jury verdict, and like Fred, I've had trouble getting the courts to listen to what I've said, but the case that struck me as being most similar that Bruce and I have worked on to Connor is a case we worked on several years ago in Massachusetts, where a newspaper reporter at the Boston Herald had a story in which he relied on an anonymous source, and the anonymous source had overheard a judge say of a rape victim, quote, "She's 14, she's been raped, she's got to get over it." And the reporter got that from his single source, who was anonymous, used it in a story about how this judge was out of control and was disparaging crime victims. And the judge ended up suing. Judge Ernest Murphy sued the Boston Herald. And this story became a big media sensation in Boston, and it was on cable TV, it was all over the internet. And like the Connor case, the reporter had a single anonymous source. Like the Connor case, the reporter had written down the source's comment verbatim. Like the Connor case, there were no other red flags going up in front of the reporter that anything was out of character. Just as in 1960 you could believe that Bull Connor would have made a statement like that, if you were covering the courthouse in Boston and had been following Judge Murphy, you would have not hesitated to have believed your source that Judge Murphy was capable of making a statement like that. Here's the problem we ran into in Murphy. One of the judges on the panel at oral argument, in fact the judge who actually ended up writing the opinion, had authored an op-ed a couple years before that in which he says, quote, "It pays to be a bit skeptical about judicial horror stories, especially those fed under the courageous cloak of anonymity." So this is a judge who had written about the danger of using anonymous sources. He specifically had written about the danger of using anonymous sources when writing about the judiciary. And as it turned out, he had even written more specifically about the danger of using anonymous sources about the judiciary in reportage on sentencing decisions, which was everything that our story was. So we had a tough time up there at the SJC, and Bruce took the brunt of that argument. But in thinking about the Murphy case and the anonymous source in the Murphy case, and thinking about Connor and the courageousness of that decision and the anonymous source in the Connor case, and trying to draw something out for you about why an appellate court in 1966 would look at a single source story with an anonymous source and strike down a jury verdict under the New York Times rule versus an appellate court in Boston after 40 years of New York Times versus Sullivan jurisprudence all over the country, expanding the reach of actual malice. And then we get to Boston and one of the bastions of American intellectual life, and we've got the Connor case, we've got the exact facts of the Connor case, and we don't win. And one thing that I thought I would close with is just interesting in terms of impressionistically, is that the Fifth Circuit, in looking at the journalism, and let me read you a little bit of the journalism because it's just incredibly powerful writing from Salisbury, and I think it's just worth it to read a little bit to feel its power. He says, "From Red Mountain, where a cast iron Vulcan looks down 500 feet to the sprawling city, Birmingham seems veiled in the poisonous fumes of distant battles. On a fine April day, however, It is only the haze of acid fog belched from the stacks of Tennessee coal and Iron Company's Fairfield and Ensley works that lies over the city. Every channel of communication, every medium of mutual interest, every reasoned approach, every inch of middle ground has been fragmented by the emotional dynamite of racism, reinforced by the whip, the razor, the gun, the bomb, the torch, the club, the knife, the mob, the police, and many branches of the state's apparatus. In Birmingham, neither blacks nor whites talk freely. A pastor carefully closes the door before he speaks. A Negro keeps an eye on the sidewalk outside his house. A lawyer talks in the language of conspiracy. You read that prose, and it's like W.H. Auden in a newspaper. It's just spectacular writing. And what you see in the piece is that Connor comes into it, but that Salisbury wasn't gunning for him. Salisbury was doing something quite different in the story, and the Fifth Circuit says, clearly, these are not the actions of a sensation-seeking publication or of careless and shoddy reporting. And then you get to the Judge Murphy case and the SJC, and the court doesn't respect the journalism. And when the court doesn't respect the journalism, the court doesn't respect the use of the anonymous source. And so what the SJC says in the Murphy case is that, our reporter who did everything that Harrison Salisbury did in terms of relying on a single anonymous source, but doing so in a way where it looked to the court that he was gunning for his subject. The SJC says, quote, "The reporter wrote an incendiary story intending that it create a media sensation." They just hated the journalism. And in closing, I think where it leaves us as media lawyers today is that we're not going to be able to turn the courts, I think, for us defending our clients to a place where they are more comfortable, I think, expanding and supporting the law that they've already established until we can get them comfortable again about the quality of the journalism and that the news media will use its rights, protections for anonymity responsibly. I would love to take some questions. Otherwise, I'm very eager to go home and plug in all my neighbors' names to find out who they've been contributing to. I always suspected we had some socialists and fascists on the block, so now I'll get to see. But I would love to, if anyone had any questions about any of the, or for Bruce, questions that we see in our practice. Nothing? Bruce, any other comments? No?
Thank you very much.
Thank you.
Thank you very much.
Thank you. Thank you.
So it remains only to say thank you to our speakers, Bruce Sanford and Bruce Brown, and to say thanks to Josh Wheeler and Amy McClung from the Thomas Jefferson Center, and to the students from the Journal of Law and Politics who will preserve these ideas for posterity, and to you for coming. Thanks very much. We're at an end.